Diana,
Yes, Judge.
last night,
Yes,
and Zach, you'll appreciate this.
yes, Judge.
Last night, I was just singing to myself and people heard me singing. And they said, hey, you are really a good singer. I'm like, no, I'm not. So then they said, hey, come with us to this club. They have an audition. You could win all this money. I was like, yeah, I'm really not a club type person. So they convinced me. I go and I meet this guy who's the DJ there. And he's like, look, we lost our act, because believe it or not, the Commodores were coming. And they said, we've lost our act, they're late, they're on the side of the road. Could you get up and sing? I'm like, I'm not really that good of singer. I was wearing a dress buttoned up to my neck. So somebody said, just unbutton the dress a little bit. So I go on stage and I start singing. And the first song that comes to mind is Last Dance. And that's where I met the guy that I was meant to be with.
Is it right? I knew. I said it.
Yeah.
I knew.
And you know what? And here's the thing about it. Everybody who went to this club, they didn't go on Saturday or Sunday or Monday, Tuesday, Wednesday, or Thursday.
They went on Friday, Judge.
TGIF.
Thank God it's Friday that you're talking about.
That's the name of the movie.
Back in the day, and that movie is from like the 70s, back in the day, all of their movies, they would have groups in it. So in that movie, Donna Summer was the person who got on stage and sang Last Dance. The Commodores were stuck on the side of the road and trying to get to the club so they could play, to the disco club so they could play their instruments. That was a great movie.
That's on the list, Judge.
Oh, and after it was done, everybody came back to school on Monday. TGIF, because that's when you were hip when you said TGIF. Oh, this is the other job I had, Zach. I don't know if you know this.
Oh, Judge, no, please.
Oh, I used to work at a car wash. And you know what? Sometimes if you got a fill up, you didn't have to pay.
Is that right?
That is right.
For the car wash.
For the car wash. But you know what? I would work and the cars would never seem to stop coming.
Working at the car wash?
Oh, we went from movies to song, Judge. You. Come on. Come on. I'm just a humble third chair judge. I ain't no first chair. I can't make those leaps, Judge.
It's a movie as well.
Working at the car.
And work.
Yeah, it's called The Car Wash. That's the name of the movie.
And the song?
Yes, and Richard Pryor was in it. And the Pointer Sisters were in it.
Is that right?
That is right.
Glad you pointed that one out for me.
I did. All right, guys, I'm going to call the docket. After I call the docket, the first thing we're going to do is we're going to have closing arguments in this jury trial. Fernando Cordova Mejia. Okay. Joe Hernandez. Okay. Jared Hernandez Henry. Custody. Robert Klein.
I'm here for him, Judge. I do expect him, but he's in a wheelchair, so.
All right, we'll wait for him. And then we have our jury trial. Are all the jurors here? And congratulations on your first chair appointment.
Thank you, Judge.
So that probably means we're going to end up losing Allie.
Judge,
Probably, but we don't know for sure yet.
we'll never lose her, Judge. She'll always be right here. Please let the record reflect I'm pointing to my heart, Diane.
Dana's just like, oh God.
It's Friday.
Yep. One time, Allie and I were together and it was nighttime. And there were 3 children and I flew into the window.
You flew into the window.
Yes, I did.
Were you riding on something, Judge?
No, I was not.
You were just flying.
I was just flying. I flew through the window and all of a sudden Allie appears. And she has stardust floating all around.
Now, were you able to fly because of Dreams Dust Dreams something and Pixie Dust?
Well, I don't know. You got to put the something in there.
Yeah, I'll hear you on the-
All right. All right, guys, we're going to go on the record.
Get them ready?
Yes. Court is calling 2020 CR 10218, State of Texas versus Jesse N.O. Could I have parties announced for the record for the state?
Alex Jackson and Zach Dunn for the state.
John Reitmeyer and Christine Brown for the defense.
Okay. And are you Mr. N.O.?
Yes, sir.
All right. Have both parties had a chance to review the charge of court, state,
Yes, Judge.
defense?
Yes, ma'am.
Any objections, state,
No, Your Honor.
defense?
No objections.
All right. And so you all both yesterday said 15 minutes?
Yes, Judge.
But Sean, should I waste my time going to see Dune? I think I have to, if you've seen the first one. It's sort of like Fast and the Furious. You got to see it to the end, although we're probably going to be on Fast and Furious 30. Okay.
Should. So I told her I'd get here at 9 before y'all started your trial, but I guess I'm not gonna be able to do it before y'all, because y'all look like you're ready to go.
Oh, yes, they're lining them up and they're going to do closing arguments.
Oh, so maybe later this morning.
Oh, yes, they each have 15 minutes. All right, thank you.
Good luck, everybody.
Deputy Mahia, please tell me you've at least seen Car Wash. Oh, my gosh.
Ask that, Judge.
I did. You know what? Viewing Car Wash has absolutely nothing to do with your age. Everybody should have seen that for the music alone.
Can you believe that out of Mejia, Judge? I mean, come on.
I can't.
Never even seen it.
Hasn't seen it. That's like saying you've never seen the 10 Commandments with Charlton Heston and Yul Brynner. Who hasn't seen that? Ready?
All right, for the jury.
And everyone, please make sure your phones are off. There's nothing worse than doing a closing argument and somebody's phone goes off. All right, everyone, please be seated. And everyone, I was able to find parking easily, I hope. Listen. All right, I'm going to read to y'all what's called the charge of the court. Do not worry about memorizing it. You will receive a copy of it when you go to the back. Charge of the court, members of the jury. The defendant, Jesse N.O., stands charged in count 1 of the indictment with the offense of aggravated sexual assault of a child, alleged to have been committed on or about the first day of November 2018 in Bexar County, Texas. The defendant, Jesse N.O., stands charged in count 2 of the indictment with the offense of indecency with the child by sexual contact, alleged to have been committed on or about the first day of November 2018 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of aggravated sexual assault of a child if, regardless of whether the person knows the age of the child at the time of the offense, the person intentionally or knowingly causes the sexual organ of a child to contact the sexual organ of another person, including the actor, and the child victim is younger than 14 years of age at the time of the offense. Just one moment. San Antonio allergies. All right, 2, Our law provides that a person commits the offense of indecency with a child by sexual contact if with a child younger than 17 years of age, whether the child is of the same or opposite sex, and regardless of whether the person knows the age of the child at the time of the offense, the person engages in sexual contact with the child. 3, child means a person younger than 17 years of age. Sexual contact means any touching by a person, including touching through clothing of the breast of a child, if committed with the intent to arouse or gratify the sexual desire of any person. 4, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 5, the phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. There's no limitation period for the offense of aggravated sexual assault of a child and indecency with a child. The indictment in this case was filed on October 19, 2020. 6, count 1, aggravated sexual assault of a child. Now, if you find from the evidence beyond a reasonable doubt that on or about the first day of November 2018 in Bexar County, Texas, the defendant, Jesse Hino, did intentionally or knowingly cause the sexual organ of Christina Hino, a child who was younger than 14 years, to contact the sexual organ of Jesse Hino, then you will find the defendant, Jesse Hino, guilty of the offense of aggravated sexual assault of a child as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Jesse Hino, not guilty of the offense of aggravated sexual assault of a child as charged in count 1 of the indictment. 7, count 2, indecency with a child by sexual contact. Now, if you find from the evidence beyond a reasonable doubt that on or about the first day of November 2018 in Bexar County, Texas, the defendant, Jesse Hino, did intentionally or knowingly engage in sexual contact with Christina Hino, a child younger than 17 years, by touching the breast of Christina Hino with the intent to arouse or gratify the sexual desire of any person, then you will find the defendant, Jesse Hino, guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Jesse Hino, not guilty of the offense of indecency with a child by sexual contact as charged in count 2 of the indictment. Your verdict in each count must be unanimous. If there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. Evidence of any other alleged acts of misconduct by the defendant against the complainant in this case is not to be considered unless you believe those acts, if any, were committed beyond a reasonable doubt. With regards to those other acts, if any, you are instructed that said evidence was admitted if it was only for the purpose of showing the state of mind of the defendant and the complainant and the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law, as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them. but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any questions you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, State, you may proceed.
In their opening statement to you, the defense counsel got up there and told you that in general, it's terrible to see some of these elements in the penal code, that these charges can exist because these things happen in the state of Texas. And then he continued by saying that the worst thing that can happen here is when someone is wrongfully accused. That's what counsel said. Is like, that's one layer worse. Given the testimony of the evidence you've heard in this case from right there, like Judge likes to point out, the worst thing in this case is to let a guilty man walk free of consequences. It's to let a guilty man see the harm he's wrought others, that's set up on that stand, and not holding him accountable. It's letting a guilty man hear how Christina Hinojo told the outcry witness, Sam Abrego, the individual who heard from the stand, it's letting a guilty man hear, quote, that she said that she had let it happen and she blames herself. That's what she told the outcry when she was 12 years old, okay? Now, this is a crime in the state of Texas for that exact reason. Kids cannot consent. 12-year-olds cannot consent. They can't consent to someone touching their breasts and rubbing their genitals, his penis, against her vagina. 10 years older than her. That is why it's a crime. Kids cannot consent. And I want to make a quick note here about consistency, right? So in the questioning with defense counsel of his own client on the stand, he goes, well, you've been consistent, right? The only thing that the defendant said on the stand essentially was no. It was a litany of, did you do this? No. Did you do that? No. Right? That's not consistency, right? That's denial without detail, okay? This is a man that drove 5 hours without asking why, right? You heard the officer talk about how he called the defendant, drove 5 hours overnight to get there at 8 a.m. from Edinburgh to San Antonio, didn't ask why. You know why he didn't ask why? Because he knew what he was being brought in for, and he knew that all he had to do was deny without detail. But let's look at the consistency of the complainant. And again, I know I'm focusing on that outcry witness, the last person you heard from the state. That person didn't hear anyone else testify. And he said, 4 years ago, Christina was quiet. She was short in her responses, elbows on her thigh, covering her face. That's exactly the person you saw on the stand. He wasn't here for the whole trial. He told you about an interview 4 years ago, and it's exactly the person that y'all saw on the stand. And he had made multiple mentions of the fact that he's done over 2,000 interviews, and in that, he made it very clear that his interview with her matched the interview that she gave with the Center for Miracles. That is consistency. And to bring it back again, this is a young woman who said she blames herself. And we're asking to return a verdict of guilty so she can't do that. Don't blame her for the decisions that a man 10 years older made that day. Thank you.
Defense.
How many times does it take a story to be told before it's treated as gospel? True. This case, the state of Texas is going to ask you or tell you it only takes 2 times. 2 times for a story to be told before it's the absolute truth. Christina told the forensic examiner. Story number 1. Christina told the story to the same doctors when she was being examined. Story number 2. That story gets passed to a detective. Detective interrogates. Detective says, "Yeah, we got our man." That's all it takes to put a person in the same seat as Jesse Hinojo right here. We call that probable cause. We think he did it. That's not enough to convict. Thankfully, our forefathers said you need more than that to convict someone of a crime. Let's talk about the evidence we heard. As counsel for the state brought up, Sam Abrego was the last one we heard. He was the person that Christina told first in detail. Key point here, detail. He said the first time this happened, according to Christina, it happened in Jesse's bed. The third time, it happened in her bed. Second time, it was just like the third time. Detail. No independent fact checking, just get them talking. Let the investigators figure it out. That's their job. Our job is just to get them talking. Truth or lie be damned. Dr. Kellogg got up on the stand and talked to us, and she said there is no medical proof that it happened. It's inconclusive. We can't tell. All we have to go on is a story. Again, no independent fact check. We don't know. We're assuming she's telling the truth, but we can't verify. The detective gets on the stand, talks to y'all. He interrogates Jesse. Did you do it? Did you do it? Jesse was consistent. No, I didn't do it. Period. The detective said there's no scientific evidence that anything happened. Again, all we have is a story. And the detective also mentioned that he said Jesse lived in that house for 3 years. Details matter. Jesse himself said he only lived there 3 months. The complaining witness said he only lived there 3 months. Now we got to talk about Christina. Christina said first time something happened between her and Jesse was he touched her in the living room. Well, guess what? That is not what she told Sam Abrego, the person who heard it first. Not at all. She said the third time it happened in Jesse's bed. Guess what? That's not what she told Abrego. Because remember, Abrego said the third time she told him it happened in her bed. Details matter. Christina then said the second time it happened, there was some testimony he pushed her on the bed. That's not what she told Abrego. She told Abrego, yeah, it was like the third. Details matter. You heard Lupe Hinojo get up on the stand, and she spoke about what was going on. She testified, I was around the kids all the time. I would have known if something was going on because I was constantly there. She wasn't picking sides. She said she loved them both. But she would have known being that involved in someone's life. Not to mention the bedroom where one of these acts allegedly happened had 4 kids living in it. Finally, you heard from Jesse. Jesse stated he didn't do it. We went through every single point that Christina said he did. He denied every single thing. Jesse said, I barely talked to her. And I'm being accused of this? When Jesse was on the stand, state asked some questions about him, saying he got to hear the evidence because he was sitting in here and he had 4 years to get his story straight. Well, guess what? Every witness the state had the exact same 4 years to get their story straight. Details matter. Now, we're sitting in the jury, 12 people. You get to decide what's credible and what's not. You're the only ones. The lawyers that are in trial, we have a million things going through our heads. What's going to happen? What do we have to do next? Sometimes we take a break. We have to decompress a little bit. When we think about life, we think about other things. And at some point during this, I don't really know what caused me to think of this, but I thought of my great grandmother.
Your Honor, I'm gonna have to object to improper argument.
Overruled.
And the reason for that is she was a great cook. One day, I remember this when I was real little, it was a nice day. Opened up the doors, opened up the windows, you're gonna air out the house. A lot of people do that in town, and it's not a bad allergy day. She was making a pot of soup. Put everything in there, things are starting to smell good. Smell it through the house, heck, you can smell it outside. You're not gonna watch a pot of simmering soup all day, so you let it simmer. There's no lid on it. Come back, playing outside, and I hear a 90-year-old lady screaming bloody murder. On that, see what's going on. Somehow, a couple cockroaches falling from the roof into the soup. Now, she was about to feed a party. Had some relatives coming over. There's an interesting dilemma there. What are you gonna do? Do you fish out the cockroaches and feed that soup to who's coming over? Or are you gonna toss out the soup? Ladies and gentlemen of the jury, you're now cooks. And every witness who gave testimony is a pot of soup. And you are gonna have to, well, before I say that, inconsistencies in the story are the bugs in the soup. You are gonna have to decide what to do with that soup. Are you just gonna fish out the bad pieces and keep the rest? Or are you gonna toss the whole thing out? That's your job. A man's life is dependent on what you are gonna do with that soup. Make no mistake about it. State's gonna give the last word because they have to. It's their burden. They have to prove this beyond a reasonable doubt. Every element. If you have a doubt in your mind, any doubt, a doubt, single, you have to return a verdict, not guilty. That's in the
Object to a misstatement of the law of reasonable doubt.
All right, that objection will be sustained.
Hold the state to their burden. Make them prove this case beyond a reasonable doubt for every element. Don't do violence to your conscience. You go back there and talk this over and discuss everything. You're gonna have a chance to tell the state that if you're gonna bring a charge like this against somebody, you better have your ducks in a row because this is a serious charge. And we don't want innocent men going to prison for something they did.
5 minutes. State.
Family is everything until they betray your trust. Jesse moved into the home of his aunt and uncle where his 5 cousins lived: Carmen, Christina, Angel, Rogelio, and the little baby niece that Lupe couldn't remember. And he violated their trust when he violated their 12-year-old daughter. Let's talk a little, before I get into why we know this happened and why you should believe Christina, let's talk a little about defense's argument. Their main thing seems to be a scare tactic of don't wrongfully convict someone. Don't convict just in case he's innocent. Well, folks, that doesn't apply here because he's not innocent. He did this to her. And we'll talk further in a little bit about why we know that. We also talked about, oh, there's no medical proof. Well, we talked about that in Guadire. When we picked this jury, I already told you, hey, we're talking about a delayed outcry. There's going to be no physical evidence. This juror in the back with the glasses, he even said time. Time is going to make a big factor in this. Time is the enemy of medical evidence. And then Dr. Kellogg came on the stand and told you that even if it had happened relatively soon, there still may not have been physical evidence. Our bodies are designed to heal. There's no evidence. Fine, we don't need it. Because if we needed it for every single one of these types of cases, no one would ever get convicted and millions of children would go without having any justice. Because most of the time, there is no physical evidence. Most findings are normal. Dr. Kellogg told you that. Next one from Lupe is, oh, they were never alone together. There was never an opportunity. Guys, details do matter, but Lupe, their own witness, shows that people can have details slip. She couldn't tell you the youngest niece's name, who I know she loves her, doesn't mean she doesn't know her. She couldn't tell you exactly when she moved in or exactly when Jesse moved in. She kept insisting that when Jesse was there, the kids were in school, and so he never would have been alone. Jesse himself told you, no, I lived there over the summer. The girls weren't in school. So the never alone together thing, it just doesn't make sense. You're expecting us to believe that during the summer, a 12-year-old girl and her 9-year-old sister are going to spend all day, every day in a tiny bedroom with their toddler brother and their infant sister? No, Lupe is busy watching the toddler and the infant. Angel or Jesse himself told you that there were times that Christina came to the room in the back that he shared with Angel. Jesse himself contradicted Lupe's testimony. There's plenty of opportunity. This isn't some long drawn out thing. It's a clandestine thing. You don't want to get caught. And they almost did get caught, which makes sense, folks. It makes sense in a house full of people. Details matter. And it's best illustrated when the whole details change for Christina's story. The key points didn't. She was always clear. He groped my breast. He rubbed his penis on my vagina. That has never changed. Lupe helped illustrate that even adults can get things a little confused. And she herself said, hey, it's been years. And in fact, it has been years. She was 12 when it happened, and she was 17 coming up here to talk to you guys about it. Think how long that is for a teenager. To us, it's nothing. 5 years is nothing. But to a 17-year-old, it's it's like half their life. Yeah, details are gonna slip, but the key point that she was victimized by her adult cousin 10 years older than her, that doesn't change. The main thing that they want to get across, and that Jesse himself said, is just, she lied. Great. Why? Offered no explanation. There was no testimony from Jesse or Lupe or anyone else involved as to why a 13-year-old, because that's when she told, why a 13-year-old would make this up out of the blue, why she would In the midst of a mental health crisis, she got up on this stand and told you about how she was suicidal, she was depressed. In the midst of that, she finally told someone, hey, this may be why I'm acting out. She had to go to Center for Miracles, sit with a grown man. Y'all saw Sam. He doesn't look like a kindergartner teacher. He looks like a grown man. She had to sit in a room with a strange man and tell him about the most horrifying experience of her life, covering her face, emotional, clearly not wanting to talk about it. Then she had to go to Center for Miracles, meet not just with Dr. Kellogg, but also with the main doctor performing it while Dr. Kellogg observed, talk again in detail of the abuse she suffered, suffer a full body head to toe exam, including exposing her genitals. She had to get swabbed for STDs. What 13-year-old wants to do that? Especially one who already has low self-esteem, who's already has suicidal ideations. They don't. They're only doing it if they're trying to get help. And then, not only that, 4 years later, when she's tried to move on with her life, take time out of high school, time away from her friends, come into a courtroom and tell a whole room full of strangers once again the horrifying details of what she went through. And you saw how painful that was. You saw how nervous she was, how she could barely even look at me. She was terrified. She didn't have to do that. At any point, she could have said, you know what, I'm out. We could have made her come on the stand and she could have refused to answer questions. She could have said, I don't remember. She could have had an out at any time, and she still chose to come here and subject herself to being questioned and called a liar, to have questions asked of her to maybe imply that she had, romantic feelings for the defendant, to sit here and have the perpetrator once again say, oh no, you should believe me, she's a liar, I'm the only one telling the truth. How dare he? Finally, yeah, Detective Bierman, not the best investigation. And details do matter. He got the time wrong, but that's fine, because Katrina always had the time right. She's the one witness you have to believe beyond a reasonable doubt. Detective Bierman also kind of got mixed up on what constitutes aggravated sexual assault of a child. So yeah, not the best investigation, and he could have done better, but don't put that blame on her. She already blames herself for what happened with an adult 10 years older than her. Do not put any bad investigation or, oh, they could have done more. Who cares? She brought you the evidence. She brought you her story and told you about how after this, she lost herself.
4 minutes.
She lost herself and she fell into a depression. There is more than enough reason to believe her because she gave you no reason to doubt her. These types of cases occur behind closed doors. It should terrify you to say, oh, somebody could get away with it because there's no physical evidence or because no one saw. No one ever sees. That thought should terrify you for your children and your grandchildren because you're telling them, hey, kids, you better tell right away and you better have gotten DNA evidence. Otherwise, we can't prove it. Or, too bad, so sad. Did you film it? Oh, you didn't film it? Oh, well, we can't prove it. No. There may be pieces missing, but we all know what this is. You need to ask yourself, do I have a doubt? Is it a reasonable doubt? But was it about one of the elements Zach and Allie had to prove? The answer is no, the verdict is guilty. And we are asking you to stand up for Christina and say, hey, you have waited almost 6 years for justice, and that day is here. Find him guilty.
All right, ladies and gentlemen, I told you that I would let you know when it was time for you to begin your deliberations. So after you go to the back and choose your presiding juror, then you can decide your deliberations. All right, can we go to the side, please? Norma, oh, sorry. Bobby Gebbia said he was gonna come down, but he's not here yet, so if he comes in the back, I'll go back there. Okay, thank you. All right, when you all are ready, let me know. I'm gonna take care of search warrant. Deputy Mahia, I'll be back. Oh, he didn't want me? Oh, there he is. Okay. And they can come around this way. Yes. Which one are you ready on?
Rod, Henry Fernandez.
All right. Diana, could you, Norma, could you have Diana come out? Thank you.
Why don't we do that, just one piece at a time, just for simplicity's sake. Or that is.
He said, basically, let him motion to withdraw today, and then you put in a motion for him to be early terminated, and then Reg Boyd makes the final decision.
All right, we're gonna go on the record. Just give me a minute, Mr. Gebbia. All right, the court is calling. Are you all ready to proceed?
Yes, sir.
Just to let you know what's happening, Judge, my understanding in this MTR is that probation's recommendation is to withdraw the MTR. We just wanted to approach it to let you know what was going on.
Okay, so what is happening?
My understanding is that he is under supervision in Guadalupe County and that their recommendation in their case was to send him to safety. And so really what it's going to be is that we would draw the MTR, see what happens in Guadalupe County. They send him to safety, then we would just be early sorry, not early terming, it would be terminal case, terminal time, sorry.
All right, so do we have proof that they are sending him to safety or no?
And so that was something that I was gonna ask probation.
Well, I can answer that, Judge.
Yes.
Because I'm
Mr.
representing-
Hernandez, Henry, come down. And if you all could
Yes, Judge.
switch.
And basically what's going on, Judge, is that I was representing him in Guadalupe County.
Mhm.
In Guadalupe County, he has that MTR. That is the recommendation on the MTR, but has that MTR been decided? The answer is no. I'm saying in terms of the judge has not ordered safety.
Okay.
So there's a chance that he would just being completely candid with the court. The issue is though, this is they're kind of crossing themselves up because this MTR, the MTR in Guadalupe triggered this MTR.
Mhm.
And so that's why we had him, or at least tried to set up to where they would be able to bring him over here. But the idea is because basically Judge, all he owes, he's done everything on probation with the exception of maybe, well, I'll let the court consider how they view it, but he's done everything on probation. The only thing he owes is about 900, I believe, 977. And the intention was to try to motion for early termination prior to this last situation that was brought up. But my point is this, Judge, it's just he's got $900 on this one. We're prepared to pay it today if the court is inclined to terminate him early. But if not, we would ask that this one be withdrawn. We deal with the court date in March. And then like they were saying, it still keeps the court in jurisdiction where if Guadalupe does not do something that this court agrees with, we'd still be back here, Judge.
Well, let me ask you this. What is the date for his case in Guadalupe County?
March.
March
28th.
March 28th?
Yes.
So why don't we do this? Since this court date in Guadalupe County is in March 28th, why don't we have the Bexar County Jail release him to go to Guadalupe County? And then if Guadalupe County, you all work out your deal there and they recommend safety, we can still withdraw the motion.
Yes, Judge.
Y'all want to do that?
That's, I think that's technically what we were saying, Judge.
All right, so
Well, a little different, but yeah,
Okay.
yeah, we get to the same place.
sometimes we have to take side streets, right?
Yes, Judge.
All
Now,
right.
Judge, he's also, though, now he is remanded without bond on this MTR.
Oh, no, what they'll do is, once I have the clerks in the back, let Guadalupe County know, they can come and pick him up, or he can be transferred to Guadalupe County to answer for those charges. I'll set this for April 1st. So if you call us on the 28th and say that case has been taken care of, he's supposed to go to safety, then probation will file their motion to withdraw.
Yes, Judge. Well, I guess what I'm getting at, Judge, is he's on bond for that case in Guadalupe County. And so it's just,
Ah,
yes, Judge. And so we're trying to get well, we were saying if they withdrew it, then he wouldn't need a bond, obviously. But if we're taking a different course, then we would ask the court, given that he is still on deferred adjudication, so technically as entitled to a bond, we would ask the court to consider setting a bond today.
well, he's on regular probation. That's what it shows on here. Is he on deferred?
My understanding, he is on a deferred, Your Honor, but I'll
No,
let the
it's-
probation confirm
It appears to be regular probation counsel.
You have him adjudicated? Okay.
Well,
Then we would still ask for the
State,
court to consider a bond.
he says he's on bond out of Guadalupe County. But Guadalupe County can still transfer him. And if you want to set this for a bond hearing, it can be set for a bond hearing with the Judge Nahara.
If we have an agreed bond amount, would the court consider the agreed bond amount, or do we just want to do the?
Oh, no, I would consider the agreed bond amount, but there need to be questions that I'll need to be asked to see if that is appropriate for him. But I know that Judge Nahara could probably take it today.
Okay.
And if he can't take it today, just let the court know.
Yes,
The
sure.
only reason why I say that is because we're in a jury trial. And then I'm presiding judge, so I have warrants. But I will make sure that this happens today.
Yes, Judge.
All right, Ms. Ferguson, can you see if Judge Nahara can take this today just to give him a bond? And then if you can give him a reset form for April 1st. Yes.
And does he have a motion?
No, see if he'll do it without a motion. Tell him I'm asking. I know it's usually not done that way, but I'm trying to expedite things. Okay. And then of course, if Guadalupe County takes him in custody, then the April 1st date won't occur.
Yes, Judge. On this.
Okay.
And just to be clear with the court, so the court knows what, was there in Guadalupe County, and they did not vacate his bond. Okay, so he's still on bond technically
Okay,
out of Guadalupe.
all right.
Yes.
All right, and everyone just give me 5 minutes and I'll be back with the search warrant and the other cases.
with court permission, we're gonna recall Klein on Thursday.
Mr. Klein has missed too many courts for me to recall it. I'll give him till this afternoon to show up, counsel. I mean, this case has been reset and reset and reset. It's been reset since September 10th, 2021. Then it was supposed to be recalled on September 27th. Then it's January 25th. And I know he has some issues. And now we've been trying to get this case set in here. He was supposed to be here on the 15th, so we said we'll recall it for the 16th. So I'll give him till this afternoon to show up. I'll be here till 5 because I'm presiding, but then I'm usually here till 5 anyway.
As the court wishes, so
Uh-huh.
I'll have, the people that are supposed to transport him here today didn't show up.
Okay.
So I'll make whatever arrangements are necessary.
All right, thank you so much. So let's say 4:30 at the latest, even though I'll be here till 5. I know the deputies, they have to make sure they transport people. I don't know how this jury trial is going to go.
I'll try to get him here by 4, no later.
All right.
I will be back.
All right, thank you so much. I appreciate it. Is anybody else ready? All right, Norma, on Bill Simmons' case, Henry Jarrett, that's reset. Yes.
We have conferred, I don't know if the court, we have an agreement.
All right, so are they able to take him or no? Okay. All right, I'll hear it. Just give me 1 moment. Let me do this search warrant first and then I'll take that up. No, that's fine.
That's fine.
Try to have my cake and eat it too.
Yeah, no,
That's,
exactly.
I don't want, I don't want to. That's it.
Okay.
That's how the cookie crumbles, I think. Some of us old timers use that phrase, Sean. You young people wouldn't get it. You young people wouldn't get it, you know? Me and Judge, we're up there.
Oh.
That judge. The judge that walked out, not the 21-year-old judge on the bench. You see how they tried to set me up there, Judge?
They did.
That was all you.
I may have set myself up there on accident, but.
That was hilarious.
So. Then I go downstairs to Russian, basically, and I'm above the- You want anything? Are you sure, Alex?
Yeah.
All right, you all come around.
Okay, we're good. Thank you.
Deputy Laura, I'm in complete shock. Do you know that Vashawn, Norma, and Diana have never seen Rear Window with Jimmy Stewart?
Alfred Hitchcock?
Yes, they've never seen it.
What a great
And guess
movie.
what? When I told Norma that Grace Kelly was in it, you know what she said? Who's that?
The Princess? Princess Grace of Monaco?
So here's the question, Charles. Was Jimmy Stewart's character, was he a stalker or just an observer?
Just an observer. Just an observer.
And did Grace Kelly commit a burglary of a habitation?
Yes. But she looked good doing it.
Yeah. Hey, Charles, I guess I can go into somebody's house and while you have binoculars, I can point at the ring on the finger.
What's that? Now I think it's not set today.
I've got the motion for return file.
Yeah, I have it set on my system as next Thursday.
Oh, okay. Yes.
But maybe in like 3 years, you'll finally get when you meet up.
I know, right? Yeah.
Next Thursday? Thanks.
They're gonna be in
And you can up your video.
Yes, ma'am. Yeah, I'm gonna go file the motion right now. Oh, it's already filed. Here's your copy.
They're going to impatient someone.
There's deliberating accents.
Do you want to come check with you next week?
And Norma, could you call Suzanne Kramer?
Yeah, she can find you.
Okay. And the person in the back?
He's an intern.
Oh, but is he interning with us today?
Yeah, but just like with the GA's office in general. He's
Okay.
just been watching the trial and stuff.
All right, are you gonna come in here and mix it up with the attorneys?
She's talking.
Yes. Are you gonna come here and mix it up with the attorneys? Because you can't learn much sitting in the back.
He's probably back here, Judge. behind
Yes.
you.
You can, watch them.
I don't want to get the way.
Yeah,
No, you're fine.
yes.
Here, you can sit up here. While we're just doing-
And then feel free to ask the deputies what they do, ask probation what they do. Yeah. Have you even gone to the back? Oh my gosh,
I know.
what are you all doing with his education?
You're falling down on it.
Yeah, take him to the back. Take him to the back.
Take him to the back.
But Sean, I need a UA. I always tell students that I teach, if you're gonna be in this field, you need to go to the jail,
Oh, yeah.
do a full tour of it, do a full tour of the prison, full tour back there. Because if you have clients, you want to know where they're being housed. It's an eye opener.
Oh,
I don't know. Child.
And Deputy Laura, I guess we could order lunch at about, what do you think, 11:30?
What was his name?
You should order Maggie.
David.
All right. Whenever we have three normies in the courtroom, it gets very confusing. Oh my gosh. One time I was in trial and there were three Stephanies and we all spelled our name correctly.
Yeah, but it's gotta be, I'm not going forward. You gotta wait it.
Did I miss one?
I mean, I got.
Oh, thank you.
I'm not going forward. So, if I put something together in a way that enhances, you know, I can do that, but you're gonna keep that in me. I'm that it? No. I'm not gonna try.
Are they gonna sequester?
I've got.
I don't know.
Yeah. In case, like I said, you want, case of fear. Which is wrong.
Look, I get it. I hope that you can. Yeah, 1 second.
At this point, I'll probably have, I'll probably. Right.
So just let me take a look and then we'll see.
Yeah, well, that's the thing I think I was thinking. And I can tell you. Yeah. Okay, well, all right, cool.
I'll get back to you before the next.
That's really what I want to do. I want to do these formal conversations. Yeah.
All right, are the parties ready on Fernando Cordova Mejia? All right, court is calling 2023 CR 11045, State of Texas versus Fernando Rene Cordova Mejia. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Charles Bunt for Mr. Mejia.
And are you Mr. Mejia?
Yes, ma'am.
Counsel, have you received all the discovery?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Mejia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count 1 and count 2 and proceeding on count 3.
No objections.
And Judge, just so you're aware, the state and defense, we did prepare 2 sets of paperwork, one for the state jail felony paperwork, and then one because originally I prepared it under just the 3rd degree to capital paperwork. So just so the court's aware.
Okay, but
I only submitted the state jail paperwork just because I thought that was the appropriate paperwork since he's only pleading on the state jail.
so y'all only proceeding on the state jail
Correct.
felony?
Yes. Judge.
Okay. Let me just write this in here. All right. Mr. Mejia, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count 3, you're charged with possession of marijuana 4 ounces to 5 pounds
Yes,
as
ma'am.
a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea.
Yes,
If
ma'am.
for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering, that's okay. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
No, ma'am. Oh, yes, ma'am.
I'll repeat it. The rights that I've explained to you, did you understand them?
Yes, ma'am.
All right. And you know that you're giving up those rights?
Yes, ma'am. I know.
Are you intending to give up those rights to enter into a plea bargain in this case?
No, ma'am. Oh, yes, ma'am.
It's kind of confusing like that.
Oh, that's okay. I just want to make sure that everybody knows what they're doing. That's why I asked that question. So we're going to try again. All right. Do you understand your rights?
Yes, ma'am.
Are you giving up those rights?
Yes.
And my understanding is that you want to give up those rights and enter into a plea bargain agreement.
Yes, ma'am.
Is that true?
Yes.
Okay. Did you understand, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, I could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
And counsel, I know that you have not been on the case for 10 days. Is that correct?
that is correct.
And are you waiving that time?
Yes, we are.
All right. And Mr. Mejia, do you understand that your client had, I'm sorry, that your attorney has 10 days to prepare?
No, ma'am, I did not. Oh, no.
Remember
Oh, yes.
we talked about that. We could reset it if we wanted to, but we didn't want to. We wanted
Yes,
to go
ma'am.
today.
All right. So you understand that this can be reset so that your attorney can have 10 days to prepare. Did you understand?
Yes, ma'am.
Do you want to reset?
No, ma'am.
Okay. All right. Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr. Mejia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
All right, court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 3. There's a $500 fine. They're recommending deferred adjudication. They're taking in consideration county court cause number 707007. I'm sorry, it's concurrent with county court cause number 7070007. They're taking in consideration 7070008. Did you understand that to be the plea?
Yes, ma'am.
Defense?
yes, Judge, except that the fine is probated. It's typed out.
All right, so the fine will be probated. Did you understand that?
So yes or no?
Yes, ma'am.
All right. State,
Yes, ma'am.
showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. They're asking that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 130 hours of community service restitution in the DOEP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense in count 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offer states exhibit 1 and all patents.
No objections.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We would like to, Judge, yes.
Anything you wish to say on behalf of your client?
Judge, I've worked with the young man now for only a couple of days, but he does seem sincere in his desire to get this past him. You don't know yet, but he's working on getting his GED. He's only completed his 10th grade education, so we'd like to have his GED become part of the terms of his probation. I think that will help him as he proceeds with this. He wants an opportunity to get past this. He understands the deferred's an opportunity to help him do that. I believe he's worthy of this plea bargain. We ask you to follow it.
All right, how old are you?
20.
Why did you drop out of school at 10th grade?
I was just going through a lot.
All right, where are your parents?
Like, what do you mean?
I mean, do you live with them or,
Yes. Yes, ma'am.
and are they working?
Yes, ma'am.
Do you have any siblings?
Yes.
How many?
3.
Older or younger?
I'm the oldest now.
All right. Do you have any children?
No, ma'am.
That's a good thing. You're not ready yet. Okay. Not expecting any children.
No, ma'am.
Okay. Who is Roland Manzo to you?
My cousin.
How often do you see him?
Not really.
And is he your first cousin?
He's like on my side of the dad's family,
Okay.
but my dad's a Tecato, a drug addict.
Okay. All right. And who is Melissa Sanchez to you?
Who that is?
Okay. And who is Ernesto Muñiz to you?
It's also my cousin.
And Julio Alvarado?
He's a friend I don't talk to.
Do you work or anything?
No, ma'am. I was doing plumbing,
All right.
but I got kind of laid off.
So how do you spend your days?
At home,
I mean, but what do you do? Are you watching soap operas?
I don't know, ma'am. I just be at home with my little brother,
And how old is your little brother?
like 3 years old.
So you have a brother who's 3,
Yes, ma'am.
and who else do you have?
I got a sister,
And how old is she?
18.
And any other siblings?
Nah, he's passed away.
Oh, I'm sorry to hear that.
Yeah.
All right, so it appears that you need to have some activities in your life, right? You just can't sit around the house, because if you sit around the house, guess what? You're going to get used to just sitting around the house.
Yes, ma'am.
And even though this is a felony, you still have a chance to do something with your life. Okay? And if you're drug tested today, what are the results going to be?
I'm not sure, ma'am. Maybe negative.
All right, so what have you used in the past?
Probably marijuana.
All right, anything else?
No, ma'am.
Do not, since you're telling me that you've only ever used marijuana,
Yes, ma'am.
is that correct? Nothing else?
Yeah, but I don't use it a lot because it's not good.
All right, so while you're on probation, you're not allowed to use marijuana.
Yes, ma'am. I know that.
You're not allowed to drink alcohol.
Yes, ma'am.
And don't start vaping either. I know people think
Nah,
vaping is
I
cool.
don't like to really smoke, but it's there.
Hey, here's the thing. Don't do it. You know why? Because they say it causes popcorn lungs.
I don't know what that is.
Oh, it's bad for your lungs and you'll need a lung transplant.
Huh.
And, you know, the only way to get a lung transplant is if maybe somebody has died. And then when they're offering to give people lung transplants, they look at certain things. And I know they say they don't, but sometimes they look at criminal history. All right. So this is what the court is going to do. There will be a $500 fine. That will be probated. This is to run concurrent with County Court Cause number 707007. Taking consideration County Court Cause number 707008. What are the court costs in this state jail? There's to be 4 years deferred adjudication, regular reporting by Zoom or in person, regular UAs. I'm gonna want him tested for levels. And I know sometimes when I give people no contact orders, you have no control over that, right? But I'm telling you right now, I'm saying no contact with Roland Nathan Manzo.
I don't know who that is.
I know, but he's in the report, so I'm just putting it down, okay?
Yes, ma'am.
There's to be, oh, that's the person who I thought you said that was your cousin.
You said, I think you said his name wrong.
Oh, it's Roland Nathan Manzo. That's what's in the report.
Oh, Roland?
Yes,
Yes, ma'am. It's my cousin.
all right. Julio C. Alvarado Jr. Ernest Muniz. And I understand that sometimes people have no control over their family. Like, for example, they may end up getting invited to the picnic or something. But I'm telling you right now, you're not to be in any type of vehicle with them or anything of that nature. You understand?
Yes, ma'am.
There's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. My understanding is McDonald's is hiring, and sometimes people like to look down on fast food places, but guess what? If you go to McDonald's, I see it all the time. You can get scholarships for college, and they can pay for different things in college if you qualify. There is to be the DOEP course, 130 hours of community service restitution. I'm going to order that you get your GED. And after you get your GED, I want you to get some kind of certificate in a trade school, or either you can go to college. And so if you're really interested in plumbing, you can get into a trade school for plumbing. You understand?
Yes, ma'am. I know.
I'm going to want field visits one time per month until further notice. Probation, is there anything else he needs?
Judge, with the trade school certificate or college, are you going to waive any of the community service hours?
The community service hours will be waived once he obtains his GED or he gets a certificate for a trade school for plumbing or something of that nature.
Okay, Judge, there's nothing else.
All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. You've had a major hiccup in your life, and your hiccup is that you're in felony court, but you're very young. You can still turn things around. I know you have issues in your house, but do not fall into the trap where just because you're around certain things, you start using things. And let me just tell you why. Your brother, who's 3, do you want him to be in a felony court?
No.
All right. Your 3-year-old brother is looking up to you because you're his older brother and he wants to be like you. And usually 3-year-olds, you can just cook a hamburger and they think the stars and the moon hang from that hamburger because you're the person. In their eyes, you're an adult. They love you. They want to be exactly like you. So make sure it's something that you want him to copy or emulate from you. You understand?
Yes, ma'am.
And the other thing, your 3-year-old brother probably follows you around all the time, and you maybe want to do something else and they want to cling to you. Let your 3-year-old brother cling to you, because trust me, when you look back over the years, you're going to regret not spending that time with them. And pretty soon that 3-year-old is going to be 16, not going to have any time for you. All right, good luck to you.
Thank you, Judge.
You're
Are we
welcome.
excused?
Yes.
Thank you.
Thank you, Mr. Bonk.
Yes, Judge, thank you.
Like integrity computer crimes or cyber crimes.
That's it right here. Absolutely.
Oh, awesome. Yes.
Yeah.
And Norma, can you see where Miss Kramer is? All right, thank you.
Morning, Judge, by the way.
Good morning. Have a good one. All right, Detective, if you'll come this way, please. Thank you. No problem. Tell your mom I said hi.
She's probably, yeah, probably second biggest fan.
Aw,
Well, no, not probably.
I love your
definitely
mom.
second, but your mom. So,
yeah.
yes.
I don't have the prosecutor that I've been talking to, but I can still argue my motion because I mean, it's just a.
Oh, yeah. I will hear your motion.
Yeah, I mean, I was dealing with Jason and then Hank, but
I'm familiar with it.
Okay. Let me just read it very quickly, then we'll take it up.
Please, I don't want that getting out. Handprint. Thank you. Happy to see you, John.
Yes, thank you. Have a good one.
You too.
All right. Are you all ready? Joe Hernandez, if you'll come down. All right, the court is calling 2023 CR 10221, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state?
Suzanne
Defense.
Kramer for Mr. Hernandez.
And are you Joe Hernandez?
Yes, ma'am.
Right. The defense has filed a motion to preserve evidence. And I think it would be best if we take these one by one.
Okay.
So the first thing is an Eagle video. Does an Eagle video exist?
My understanding is no, Judge.
All right, defense, do you know whether or not an Eagle video exists? The
I
state is
can-
saying it does not exist.
It's referenced within the file, which is why I was, and notice that I didn't have anything like that in my e-discovery. So I did ask Jason to check on that. I'm not being told why if it got destroyed or if it never existed, it shouldn't have been mentioned, but I'm told that it doesn't exist.
All right, state, with regards to the Eagle video, are you able to get some sort of documentation from whoever is over that, at least send a notice to you stating that the Eagle video does not exist?
Try, Judge. I mean, there should be someone who should be able to. My understanding is that if it's Jason that reached out and got the response, then there should be an email about that, but I can confirm with Jason, but it's at least my understanding that the Eagle video doesn't exist.
All right, so I'll put in here that the state is to provide the defense with documentation that the Eagle video does not exist. And defense, is you still think that somebody hasn't looked somewhere and you
I'll
want to
let you know.
subpoena the person with Eagle, then you can subpoena them and we'll have a hearing on that.
Okay, thank you, Judge.
All right, then the next thing is a surveillance video from a hotel.
Yes, Judge. At the first setting, by the time we got really to the first setting on this case, it appeared that I had a lot of discovery, but I didn't have any kind of a surveillance video. Being a hotel, I thought there might be one. So at that setting, I asked Jason to check, and apparently he did check. Apparently he called the hotel owner, and the hotel owner told him he had the video, but he wasn't going to give it to him. I never did get any email letting me know of that conversation, but Jason didn't subpoena the video after that. That was at this last setting when I discovered that. Then you ordered the state, and this may have been done by now, to subpoena the video, but out of an abundance of caution, I just wanted to make sure that I did everything I could to make sure that we got that. If it does exist, because the hotel owner told Jason he wasn't gonna give it to him.
All right. State, do you have an update on the hotel video?
I just, Judge, it made me worried with the hotel owner being reticent to give it to the state upon request that he may destroy it.
Okay, just one moment. Let me write this down. All right, so does it shows that it's actually been subpoenaed or has it not been subpoenaed?
So it's just a note from Hank saying that, he wants this, if I look into the case. That is been generated. So
All right, so a subpoena needs to be generated for that video. And that needs to be generated today.
Judge, my understanding from looking at the notes, it's not that he's not willing to give it to us. I think, at least as far as from the notes say, I don't know what Jason, there's no note regarding Jason's conversation, if that happened. But just that, SAPD tried to reach out to the hotel owner and he never responded to any calls. So that's at least the only notes I see.
All right, so this is what's going to end up happening. The hotel owner, whoever it is, it's probably best for them to be subpoenaed to come to court and bring the video, do a subpoena duces tecum. And that way we will know if the video is still in existence. And state, I understand what your issue may be with the motion that I'm ordering you to order somebody to preserve something that you don't have. So what we're going to do is, with regard to that video owner, let me see. We're going to recall this for February 22nd. That'll be on a Thursday. Are you available?
I'm sure I am.
All right. So state, you need to subpoena that hotel owner and do a subpoena duces tecum to have them bring that video in.
Thank you, Judge.
Sure. So Norma, we're going to have a hearing with regards to the video, the hotel video on this case on February 22nd. All right. And then let me see what else is in here.
I think that pretty much should cover it, right?
Well, you have body cams, dash cams, state. The police, I'm sure, know that they're not to destroy or purge, let me purge any body cams. And I don't think the body cam is purged while the cases are open. Am I correct?
Yeah.
All right. And then she wants preserved forensic samples, photographs, negatives of photographs, videotapes, fingerprint samples, or other material of a forensic nature, including evidence collected at the crime scene and any actual physical evidence. Any objections to that?
Under Michael Morton Brady. Serve that.
I'm sorry, Dan.
Under Michael Morton Brady, we have to say that.
All right. And number two, any body cams, dash cams, surveillance videos, and surveillance videos, we've addressed that.
Yeah.
So is there any objection to the court removing that from number
That's
two?
fine, Judge.
So then it's number two is then any body cams, dash cams, photographs, audio tapes, and or videotapes made, and any maps, sketches, and or diagrams made in connection with the state of Texas investigation of the alleged crime.
And Judge, under Michael Morton Brady, I don't think that you have to go. This goes.
Okay, you're gonna have to keep your voice up for the court reporter.
Sorry, Judge, under Michael Morton Brady, I think we just have to preserve any of that and provide it to the defense if it's in our possession or if it exists.
Number 3, any and all reports, laboratory analysis requests, notes of lab personnel and or technicians, slides, samples, and any other documentation of whatever kind associated with or relating to the accused or the offense with which he is charged.
And again, Judge, I think under Michael Morton Brady, we have a duty to preserve that and to provide it to the defense.
Number 4, any notes or reports, whether handwritten, tape recorded, and or transcribed of law enforcement or other agents of the state of Texas, which relate to any investigations of the accused or anyone else suspected of having committed the same offense as that with which the accused is charged.
I don't believe anyone else was suspected of this crime, so but again, that exists, Judge.
Number 5, any notes, audio tapes, videotapes, or writings known to the state of Texas purporting to be the statement of any person having knowledge about the case.
That I would, just any notes of anyone with knowledge about the case, I think that covers some work products. It's kind of all encompassing, it would also include, at least from what, how it's phrased here, it kind of sounds like that would also include notes from the district attorney's office if we made notes in this case.
All right, so
Well, usually when I file these, I'm talking about different notes made by police officers and the different, that might not have made it into a supplemental police report, and those should still be preserved. Could potentially be exculpatory,
all right, so do you want to change the statement to any person having knowledge about this case with the exception of work product?
That's fine. Yeah, I know I'm not going to get their work product.
Okay. Number 6, any and all videotapes, audio tapes, and or handwritten statements by the accused or which purport to be a verbatim statement of the accused. This includes statements written by someone other than the accused, but which were acknowledged orally or in writing by the accused.
Judge, again, if it's Michael Morton Brady, we would have to disclose that to defense. So the state doesn't do it.
All right, number 7, any and all uniform offense reports or supplements thereto.
Same, Judge.
Okay. Number 8, any reports, statements, recordings, or other documentation of, by, or about fellow inmates with whom the state or its agents might have discussed any matters pertaining to the accused. Oh, I think that's similar to if you all have, somebody talks to him at the jail and they're coming.
Right.
I'm not aware of anything like that existing, but again, Judge, I think under Michael Morton Brady, we would have to disclose that to defense.
Any police logs, records, recordings, and or notes of calls and reports to the state of Texas, its agents or employees, or any other law enforcement agency regarding the accused, his arrest, or incidents related to the indictment or charge pending against the accused.
Similar to the other stuff on Michael Morton Brady, if there's anything that's related that we're aware of or that's in our possession.
All right, then what the court has done internally, what's agreed to is 1, so the court will grant it. Number 2 is agreed to, and the court will grant it. Number 3 is agreed to, and the court will grant it. Number 4 is agreed to, and the court will grant it. Number 5 is agreed to with the inclusion of the words with exception of work product, and that will be granted. Number 6 is agreed to, and that will be granted. Number 7 is agreed to, and that will be granted. Number 8 is agreed to, and that will be granted. Number 9 is agreed to, and that will be granted. And then with regards, also the state is to provide documentation of the existence or non-existence of an Eagle video. And with regards to the hotel owner and the video, there should be a hearing of that on February 22nd, 2022 at 9 a.m. The state will subpoena the the hotel owner and do a subpoena duces tecum and have the video here. Of course, if you all have the video before February 22nd, then there will be no need for the hearing on February 22nd.
Thank you, Judge.
All right, is there anything else, counsel?
There is not, Judge. Thank you.
You're welcome. Anything else from the state?
Judge, one thing I'll phrase is just again, I'm not aware of any conversation with Jason Garahan and the hotel owner, so again, we don't know if the video exists. I'm not aware.
All right, so.
Well, Judge, I mean, I can just represent that at the first setting, Jason did tell me that he talked to somebody, but it was represented that the hotel owner was requested of the video and he said, no, he wouldn't turn it over.
Okay. All right. Well, we're going to get him to turn that over. So state, I'm sure if you let him know, he will be in court. Then we'll probably have the video.
No, I understand.
All right. Is there anything else?
There's not, Judge. Maybe be excused.
All right. Is there a chance that your client is going to bond out?
I'm not sure that that's.
Could I get a bond reduction?
Oh, that's your attorney will file something and then we'll have a hearing in front of Judge Nahara. Ms. Ferguson, in case he's released, can you give him a reset form for February 22nd?
February 22nd?
Yes. And it will just be a discovery motion, a discovery hearing.
March 19th date?
Yes, we're still keeping the March 19th date, but we're just doing this for discovery. Thank you. And somebody is here on an iPhone. Do we have somebody who's supposed to be logging in?
That's it's the man in the wheelchair.
All right, we shall see who this is. You know what? Before I let them in, because I don't know who it is, I'm going to chat to them.
Mr. Conboy, did he asked for the Zoom ID from anyone? No, I haven't.
All right, so I'll just chat to them in the waiting room.
I know John couldn't find his comment.
Yeah, that's he didn't ask him for the Zoom ID.
Yeah, but we all have it, so he probably could have gotten it from anyway.
So we are going to sort of take our break. We're just waiting for the jury deliberations. So